I'm Kristen Smith, and at today's webinar, I spoke about employee resource groups, also known as affinity groups, and the legal concerns that you should be thinking about as an employer if you already have these groups or you're thinking of forming them. And the concerns fall into three categories. The first is wage and hour concerns. And this comes into play where you have non-exempt employees, hourly employees who are participating in employee resource group activities. If you do have employees, non-exempt employees involved, you need to think about whether you'll be paying them for the time. There are some very specific rules under the Fair Labor Standards Act that set forth when attendance at things like training seminars, lectures, meetings should be compensable. And there's 4 elements that you must meet in order to not pay the employee. So make sure you're paying attention to those rules, which include it has to be voluntary, it has to be off the regular work hours, and there are other factors to consider as well. There's also rules about when charitable work is compensable. A lot of times these resource groups will engage in volunteer work, so you want to make sure you know those rules to make sure that you are properly compensating employees. The second type of law I touched upon would be employment discrimination law. And these groups often are designed around a protected category. For example, there might be a group designed just for female executives, or there might be a group just designed for employees in the LGBTQ community within your workplace. That being said, although these groups should be, designed around supporting those groups, membership should never be exclusive to a particular protected category. That would be textbook discrimination. So just make sure when you're messaging around these groups that you're not talking about anything that might suggest exclusive membership. If someone outside that group sought to participate, join the group, participate in their activities, they should be allowed to do so. And then the third area of the law that I talked about is the National Labor Relations Act. And this applies to union and non-union workplaces alike. And the National Labor Relations Act prohibits employers from dominating or interfering with employee labor groups. And you might not instantly think of employee resource groups as being a labor organization. But if you look at the NLRA's definition of a labor organization, they sometimes do a lot of things that make them look quite a lot like a labor organization. So you're going to want to look at the types of things that the ERG is doing. For example, if they start making suggestions around improving workplace benefits, improving workplace safety, things like that. That's classic, terms and conditions of employment. I would be wary of sitting down and starting to engage in negotiating like meetings with these groups, because that starts to turn into a employee labor organization. And then if you are, as an employer, supporting that group, either financially or through some other sort of sponsorship, executive support, that could be construed as interfering or dominating with a labor organization. This gets into a bit of a complicated area of labor law, and probably something that most workplaces aren't thinking about, but there have been cases by the National Labor Relations Board finding fault with certain groups like this. And so it just needs to be very careful about what the purpose of these groups are, the way the messaging is set, and the level of involvement by management with the groups. But there's a lot more about this in the webinar if you want to check it out if you missed it. And thank you very much.